Hello, happy Tuesday. Welcome to another edition of Claim Your Justice live on Facebook. I'm waiting for my assistant to join the call here, and she'll do that in a minute. Today we are going to discuss what happens when there's accidents, and the accidents happen as a result of a construction sign. Hello, Jessica.
Hi, Keith.
There with me? Good.
Yes.
Let me turn up my volume a little bit. So Jessica, I made a brief introduction here, and I talked about what happens when there is an accident regarding a construction sign, and some people may think that there's no such type of claim, but that's why we're here.
Right.
Our job is to advise people when they may have a claim they otherwise may not think they have, and they're seriously injured. So with spring and summer upon us, we're going to spend a few weeks this season talking about construction-related accidents, and then we're going to move into talking about motorcycle accidents. That season's coming upon us in a month or two. Everyone's going to have their motorcycle out of their garage, be on the road. Drivers aren't ready for it, so we'll talk about that next. There's several issues with construction sites, and the accident can happen to a pedestrian. The injury could happen to a motorcycle rider. It could happen to a person driving a car, person driving a truck, or a mother pushing her baby in a stroller. So why don't we get started, Jess? Ask me your first question.
First question, Keith. If a pedestrian is walking down the sidewalk and trips and falls over a construction sign that fell down and is seriously injured, can they make a personal injury claim?
It's a good question. So we all see in situations where there's a construction project, there's a sign that may say road closed. There's a sign that may say the lanes are converging from 2 to 1. And the problem is those signs aren't always secure. So with any question regarding a personal injury, we need to first evaluate the 4 requirements for there to be a personal injury claim. We have duty, we have breach of duty, we have proximate cause, and we have damages. Damages are the injury. So the duty, when the construction company or a company that rents construction signs puts up that sign, they erect the sign, they install the sign, they need to make sure it's secure. I'm sure many of us have seen construction signs with sandbags over the bottom of them. But those sandbags aren't there to look pretty. The sandbags are there to hold those construction signs in place. So when they have the sign erected, they have a duty of care to make sure that the sign is erected properly. If they breach a duty of care, if they don't put the sandbags on it or otherwise don't properly secure it, then the duty of care is breached, and we now have to look at the proximate cause. The proximate cause kicks in because but for or otherwise known in law foreseeability, but for that breach of the duty of care, there wouldn't have been the injury.
Could you explain further proximate cause?
Yes. Jessica, your volume, I could hear you a little bit, but if there's any way you could turn up your volume, it may.
Can you hear me now? A little better?
I could hear you now. Bring them on the video. Okay. So we talked about, we're going to have to watch this back, make sure there's new Facebook technology. Actually, it is both of us. Otherwise, I'm talking to a black screen. Okay, proximate causes. It's foreseeability. Is the conduct of the negligent party foreseeable to cause the injury that was caused? Is it foreseeable that if the construction company doesn't properly secure their signs, that the sign would fall down, perhaps fall on a sidewalk, someone's walking down the sidewalk, trips and falls over it, hits their face on the ground, breaks their nose, gets a scar on their forehead? Is that foreseeable? So that's what proximate cause means. Very basic principle in the law, but we could break it down to 2 words, but for. But for the sign company not doing what they're supposed to do, there wouldn't have been this injury.
Right. And when would the construction company not be the proximate cause?
So that's a good question. Let's say you have the construction company puts down the sign and they put the sandbags down on it. It shouldn't fall over. There's a very strong wind. The wind is not able to be at such a velocity that it blows over the sign. But let's say two young teenagers are on their bicycle. They come up to the sign, they're like, hey, the sign's kind of in my way, I don't like the sign, and they push the sign over. There wouldn't be the foreseeability by the construction company that people were going to come and push the sign over, leading to being on the ground, leading to our client tripping and falling over it and seriously injuring themselves.
Okay.
What's next?
So you just went over signs on the sidewalk, but what about the signs on the roadway?
Okay. So if the signs are impeding the sidewalk, they're not supposed to be where they are, and someone trips and falls, that's one type of facts that we've had in the office. Another set of facts are, let's say you have what I talked about, you have a sign on the roadway, and it's telling the cars to merge from 2 lanes down to 1 lane. Very standard, we've all seen those signs. Now, if the sign gets blown over and the driver in lane number 1 has to take an evasive action to avoid hitting the sign or causing some other type of damage to the sign, and in swerving away from that sign, the driver in lane number 1 hits the driver in lane number 2, then you're going to have negligence, because if the sign company didn't weigh down the sign properly and wasn't expecting the wind, that's too bad. They had to properly secure it. The construction company didn't. The construction company breached the duty of care to the drivers on the roadway. And so what happened in that case, you'd have driver number 1 who swerves out of his lane or her lane into lane number 2 can go after the construction, make a claim against the construction company. But in addition, the driver in lane number 2 who is injured hypothetically in this accident can go after both the driver that swerved into him and the construction company. And what that does, that allows for some of these higher limits of coverage that may be necessary to compensate a client for their injuries. And we've talked about those types of limited coverage in the past. So everyone, our goal here is to provide you with access to claim your justice. It's in our name. It's the principles we live by day after day, case after case, client after client. You could reach us 24 hours a day, 7 days a week. You can call us at 866-885-HURT or 847-434-3555 or at claimyourjustice.com. We're ready to help you achieve the compensation you deserve for your injuries and to help you claim your justice. Until next time, have a great rest of your week. Thank you, Jessica.
Thank you.
Bye.